Constitutional Law 2 in English, President's Rule or Constitutional Emergency or State Emergency is the topic for discussion today. This topic, State Emergency or Constitutional Emergency or President Rule, is a topic from Emergency Provisions from Constitutional Law. In the last class, I explained in detail National Emergency. Article 352 to 360 of Indian Constitution from Part 8 of Indian Constitution speaks about emergency provisions. As already told in the last class, there are three kinds of emergencies, namely national emergency, state emergency or president's rule, and constitutional. Third one is financial emergency. Out of these three, national emergency, state emergency, and financial emergency, I explained in the previous class in English, lecture number 212, national emergency. Going to paucity of time, I wouldn't be able to complete this state emergency and financial emergency. Today, I wish to take up state emergency or president's role and financial emergency. As I told in last class, this national emergency is imposed owing to war or external threat or armed rebellion in India as a whole or any part of the country, owing to war or external aggression or armed rebellion. Previously, prior to 44 amendment, it was internal disturbance. Second one, national emergency is imposed under Article 352. I explained in detail. Second one is state emergency, which is to be imposed by President of India under Article 356. And finally, financial emergency is to be proclaimed by the President of India under Article 360. In last class 212, I explained in detail about national emergency, when it was imposed, what are the consequences, what are the procedures, and state emergency and financial emergency are to be covered, which I am going to cover in this class. As a whole, the procedure for emergency is identical for national emergency or state emergency or financial emergency. In India, national emergency was imposed on three occasions. President rule or state emergency was imposed in India on several occasions, which we are going to discuss. Financial emergency has not yet been imposed. The situation arose in 1991 for imposition of financial emergency, but the government managed to get the things done smoothly and it was not imposed. Today, I wish to take up President's rule. What are the circumstances under which this President rule or state emergency has to be imposed? What is the duration? What is the procedure? And what are the consequences of President's rule or state emergency? How many times it was imposed in India on different occasions? What is the criticism leveled against the imposition of President's rule? And what is what are the guidelines of Supreme Court judiciary so far as imposition of this President's rule is concerned, is what we have to discuss, dear friends. Before going to take up this lecture, let me take half minute with your kind permission to pray God, pay homage to my beloved parents, Rega Apparao and late Srimati Kantaratnam, my eldest brother, Professor Rega Jagan Mohan Rao, my wife, Mrs. Balivada Rega Tirumala Gauri. I express my gratitude to my godfathers who helped me in bringing out my career to this level. Finally, I express my deep sense of gratitude to my student friends who are mainly instrumental for what I am now, as they have visualized my candidature and career and took this video channel to the tune of beyond 12,000 subscribers. I once again request you, dear friends, I am doing this job absolutely on service motto. I never get anything. Even if I get, I utilize it for some poor people or some poor temples who are small temples who do not have minimum expenditure for meeting the day-to-day needs. So coming to the topic, dear friends, there is a confusion about, I have learned from reliable sources that there had been a confusion about my lectures in English or Telugu. Dear friends, actually I taught lectures up to 145 exclusively in English, but I never thought that I would teach in any other language. At the consistent and insistent request of my student friends from Andhra state, being the native of Andhra, I came forward to deliver two subjects after 145. Two subjects absolutely in Telugu, two subjects family law and dance. Then I started every lecture both in English and Telugu. In first instance, I deliver Telugu and immediately I will place English because the English on the screen, the first English lecture will be headed on the screen and then Telugu lecture will be headed on the screen. So please make use of my lectures because I am doing this job. There are innumerable number of centers of legal education where the teachers are very, 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 very limited. And if you see the net or Google or Bar Council of India manual, you'll be able to know the number of teachers available in centers of legal education, particularly in government and aided colleges. Now, aided colleges and university faculties. Now, today, state emergency or financial emergency. In the last class, I told you part 8 containing articles 352 to 369 articles laid down the provisions relating to emergency. This emergency, Article 352 speaks about national emergency. Article 356 speaks about state emergency or president role, while Article 360 speaks about financial emergency. National emergency was imposed 3 times. President's rule or state emergency imposed several times, while financial emergency has not yet been imposed. The situation arose in 1991, but it could not be, it was not imposed. This is not managed. Now coming to the topic, state emergency or president rule. This president rule was designed and incorporated in this emergency provisions constitution to avoid group conflicts owing to communism. Our Indian constitution was came into force on 26 January 1950. The preambular slogan of our Indian Constitution was to establish socialistic pattern of society. Socialistic pattern of society in the sense the goods and commodities, production of goods and commodities will be taken up by the government so as to enable the people to make them available, to make the goods and commodities and other services available at the cheaper rate. That was the slogan. But in course of time, privatization, urbanization came into existence is what we are witnessing in the recent past. However, in view of this socialistic pattern of society, the communistic activities started increasing in India, particularly in Telangana state, Telangana area of our Telugu, in Telangana area. That's why to mitigate and these communistic activities and other internal disturbances, this Article 356 was designed to incorporate president rule, to impose president rule, and this article was incorporated or added to the inserted in the Indian Constitution. So, according to Article 356 of the Indian Constitution, this article confers power on the President of India to impose president rule or state emergency or constitutional emergency when he is satisfied on the report submitted by the governor of the state concerned, stating that the government of that particular state is not being run as per the provisions of the Indian Constitution. The constitutional machinery is totally failed, and there is a lot of internal disturbance, and in the state as a whole or a particular part of the state. On the report, on the report of the governor, the President of India proclaims state emergency or constitutional emergency or president's rule. In order to impose this president rule or constitutional emergency or state emergency, there must be failure of constitutional machinery as per the report of the governor or the President of India suo motu can proclaim this president rule if he is fully satisfied that the constitutional machinery in the state is totally failed. The government is unable to, the state cabinet is unable to run the government owing to lot of internal disturbances and other constraints. So, for the purpose of whether national emergency or state emergency or financial emergency, in the first instance, the Union Cabinet, that is Council of Ministers, Union Council of Ministers, headed by the Prime Minister, has to meet and recommend the President of India, give their consent to present their proposal before the President of India is condition president. Union Cabinet's decision headed by the Prime Minister, not by the Prime Minister alone collectively. That is first thing. Second thing is the President on the report of President suo motu or on the report of the Governor as to the constitutional failure of constitutional machinery, he can impose. That is second thing. When once this president rule, whether it is national emergency or financial emergency, when once the proclamation of emergency is imposed, it should be approved by the two houses of the parliament, that is Lok Sabha and Rajya Sabha, by two-third special majority, it should be approved. If the Lok Sabha in sessions is not in sessions or the Lok Sabha is dissolved, this proclamation of emergency, whether state or national or financial, is not this Lok Sabha could not approve because of no sessions or Lok Sabha is dissolved at that time and waiting for fresh elections. Then if approved by the Rajya Sabha, this proclamation should be approved by Lok Sabha also after fresh elections, new Lok Sabha first within 30 days of its first session. Within 30 days of its first session. That is this thing. If this, when once a proclamation of emergency imposed by the President of India, whether it is national emergency or president rule or financial emergency, it will remain in force for 1 month in respect of, in case of national emergency. It will remain in force in respect of state emergency or financial emergency. When once the proclamation of emergency has been imposed by the President of India, it will remain in force for a period of only 1 month in the case of national emergency, or it will remain in force for a period of 2 months in case of president rule or financial emergency. After imposition, irrespective of approval, it can be revoked, it can be withdrawn after 2 days. First, national emergency or state emergency, financial emergency is imposed. But it can be without approval, we waiting for approval of Lok Sabha and Rajya Sabha. It may be withdrawn, revoked at any time by fresh proclamation, by subsequent proclamation. That is another thing. When once the proclamation is in force, if it is national emergency, in another place also fresh emergency can be, one more emergency can be taken. Suppose if the situation is actually arose, war or external aggression or armed rebellion actually arose or in anticipation, national emergency can be imposed. If it is state emergency, one state emergency is imposed in one state, some other state emergency may be imposed subsequently in some other state. If the disturbance may be state as a whole or any part of the state, on that basis also it can be imposed. So, if state emergency or financial emergency, when once it is imposed, it will remain in force for a period of 2 months. 2 months. At any time, by subsequent proclamation, it can be withdrawn, or if it is not approved by Lok Sabha or Rajya Sabha, it can be withdrawn. When once it is imposed, whether national emergency or state emergency or financial emergency, when once it is imposed, it will remain in force for a period of 6 months. For another 6 months, one more one more approval of Lok Sabha, Rajya Sabha should be there. Accordingly, whether national emergency or state emergency or financial emergency can be extended for a period of 3 years only. But whereas in the case of Punjab, state emergency was extended up to 5 years. 2 more years by subsequent proclamations of the President of India, and subsequently the term of 5 years was withdrawn and restored at 3 years so far as Punjab is concerned. As we are discussing in detail particular about state emergency, the President of India on suyo moto or receiving recommendation from the or receiving report from the governor or subject to consent or approval by the Council of Ministers headed by the Prime Minister, can proclaim state emergency or president rule in any state or group of states in the country on single occasions or different occasions. It can be imposed. When once the state emergency is imposed, it will remain in force for 2 months. Meanwhile, it should be approved by the Lok Sabha and Rajya Sabha within 2 months. If the Lok Sabha is either not in session or the Lok Sabha is dissolved, when once after completion of Lok Sabha elections, when once the new government is formed and new Lok Sabha first session is convened, from the first session, from the date of first session, within 30 days, the Lok Sabha also should approve if it was already approved by the Rajya Sabha long back. Now, when once proclamation of Cabinet Council taken decision, President of India imposed the proclamation of emergency. If the proclamation of emergency is approved by the Rajya Sabha and yet to be approved by Lok Sabha, and 1/3 of the Lok Sabha members may oppose it. 1/3 of the Lok Sabha members may oppose it, and with either it is already approved by Rajya Sabha or not yet approved. When once the matter comes to Lok Sabha for approval, 1/10 of the Lok Sabha member can give representation to the Speaker of the Lok Sabha. In the absence of Lok Sabha sessions, they can give representation to the President of India not to impose this proclamation. If when once the representation is received by Lok Sabha Speaker or President of India, as the case may be, the sessions of the Lok Sabha must be convened within 14 days to take decision. If it is imposition of a proclamation is approved, it will be approved. Otherwise, when once it is not approved, then the emergency ceases to exist. This 1/10 members, 14 days convention of sessions and 14 days decision is common for national emergency, state emergency, financial emergency. The rules and regulations as to the procedure are almost common, but if national emergency is the reasons for emergencies are different, and national emergency, the duration for national emergency is 1 month. The duration after proclamation for state and financial emergencies, the reason for national emergency is different, the reason for state emergency is different, and the reason for financial emergency is different. So far as President rule is concerned, the state government, any state government is not able to run the government in strict adherence to the provisions of the Indian Constitution. As a result, the government is totally, the state cabinet is not able to run the government properly due to internal disturbance and other political constraint. This is the position. Now coming to the procedure is a proclamation of emergency, and now here this concept failure of constitutional machinery is a confusing topic. The Constituent Assembly, which was designed and elected in 1946, which met first time for preparation of Constitution of Independent India. The Constituent Assembly was elected consisting of nearly 288 or something members for just like state assembly of big state. The members for the Constituent Assembly was elected for the purpose of preparing constitution for independent India after independence. So in that 8 committees are there. One committee chairman is Dr. B.R. Ambedkar ji, Bhimrao Ramji Ambedkar. He was the Constituent Assembly member, and Jawaharlal Nehru was the member, chairman for 3 committees. Vallabhbhai Patel was member for 1 committee, like that. And this is the position. At the time of drafting Indian Constitution, some members of Constituent Assembly expressed opinion. This center may invoke Article 352 for national emergency, or 356 for state emergency, or 360 for financial emergency. It may be misused for political gains. They expressed the doubt. So far as the president rule or state emergency is concerned, what constitutes a failure of constitutional machinery was not defined or explained by the Constituent Assembly. When this failure of constitutional machinery is not well defined, this Article 356 the center may invoke Article 356 to discriminatory imposition of this president rule in any state. This was the opinion expressed. So this is in view of some criticism leveled against from people on different levels. This parliament, through the Ministry of Home Affairs, appointed a committee. This view also regarding failure of constitutional machinery, also a team of administrative reforms committee administrative reforms of Constitutional Assembly members expressed opinion, and a team of administrative reforms committee also expressed their opinion, their doubt about what do you mean by this failure of constitutional machinery. It may be misused when once it is not well defined. It may be misused. It may be misinterpreted. That because of these criticisms, this Union Parliament through the Ministry of Home Affairs appointed a committee called a commission called the Sarkaria Commission. It's called Sarkaria Commission. This Sarkaria Commission was appointed appointed in 1983, in June 1983, headed by R.S. Sarkaria as the chairman. R.S. Sarkaria chairman, B. Sivaraman and S.K. Sen as members. This Sarkaria Commission has gone through various, has inquired into various aspects and gave some guidelines. These are the circumstances which cannot be treated as a failure of constitutional machinery, and president rule should not be imposed. This Sarkaria Commission, having undergone so many, having inquired into various aspects, examined in depth about various issues relating to state affairs, provincial matters, and gave some guidelines. These are the circumstances which cannot be treated as failure of constitutional machinery. If under those circumstances, if the president rule is imposed, it is unconstitutional. It should be declared void. There are some guidelines they have given. These guidelines given by Sarkaria Commission was accepted by the collapse of state governments and assemblies case, that is S.R. Bommai case, which gave some guidelines, which approved whatever recommendations were made by Sarkaria Commission were accepted and acknowledged, approved by the Supreme Court, and these proposed by Sarkaria Commission and ratified by this Supreme Court decision in Bommai case. They were enlightened, one enlightened by Durga Das Basu, a very famous author of constitutional law, in his book Introduction to Constitution of India, in 20th edition. That what are these? Number one, if your center rival party comes to power, and rival parties are in power in some states, the center should not collapse the other state governments. For example, BJP government is now on throne at present. So non-BJP governments, for example, state government, UPA government states are there in different 5-6, but the BJP should not collapse that like that. So here in 1978, before 1977, Congress government was in power. Mrs. Gandhi's Congress government headed by Mrs. Gandhi was in power at center, and so many states Congress government was in power. Then in 1977 general elections, Janata Party came to power. So at center Janata Party, there are about 9 states Congress government was ruling. The 9 states were headed by Congress government. This Janata government said that this time the people of all your 9 states gave mandate to the mandate to Janata Party. They lost trust in your government. You can no more have you can no more have right. You can no more have any. You can no more have any courtesy to continue in power. You, the governor and the union minister of center, headed by Janata government, spoke to chief ministers of these 9 states concerned and ask your governor to dissolve your assembly and invite fresh public mandate. That was this thing. It was challenged and all the developments are there. I will explain it this thing. So that is why when center one party, the rival party is there in any state, that the center should not collapse that government. It is not a failure of constitutional machinery. If it is, if one center dismisses rival party's government, it violates. It is not violation of. It is not failure of constitutional machinery. It is violation of constitutional provision. That is there. Suppose the government, the majority, the government is running, the state government, there is a minority government. Recently we witnessed in Karnataka, sometimes Yediyurappa ji, sometimes Kumar Swami ji, like that the matter. In sometime in NTR government, NTR was there, sometime Nayadilla Bhaskar was there. Sometimes these are the cases. In Bihar also situation takes. There are so many cases. States, the incidents of political instability takes place due to minority. If any particular party could not get any major, recently in Maharashtra also, sometimes Uddhav Thackeray ji held CM post, and subsequently Shinde ji succeeded him as chief minister. This type of political instability owing to lack of absolute majority takes place in different states from time to time. When once there is no absolute majority in state in public elections, this imbalance, some MLAs of one group get slided into other group, and this time they swing between this group, this leader and that leader, resulting in political disturbance, internal disturbance, and this may be taken advantage by the center to put down the government. This is what should not be there. When one single party won't be, when if any political party could not get absolute majority, the majority party should be invited to form the government and show their majority within 6 months that is the rule. But without giving opportunity to the alternative leader, if the governor dissolves the assembly, it is unconstitutional. So if any irregularities is there, if law and order is affected in the state, and there are a lot of disturbances in the state, like Punjab long back, there was unrest in Punjab. The people were not able to move peacefully. There was a Swarna Golden Temple issues are there. Army entered into Golden Temple. So many problems took place, and the situation very frequently, once we see the paper, so many so and so are dead, so and so are dead, so particular place bomb blast. Such type of news we had to hear time to time in those days. That is why president rule was imposed beyond 3 years by subsequent constitutional amendments also, dear friends. So these are the like that. So because when once the president of India wants to invoke Article 356 for imposition of president rule or emergency, these should do it in strict adherence to the provisions of the constitution. First step is decision of the cabinet, union cabinet headed by prime minister. Secondly, he has to invoke that article 356 proclamation. Subsequently, it should be ratified or approved by the both houses of the Lok Sabha and Rajya Sabha. These are the things. So in case the judiciary can interfere in proclamation of emergency, it may be national emergency or state emergency, financial emergency. If the judicial review that emergency is subject to judicial review. Judicial review, and the court may direct restoration of normal time, peace time, withdrawing the emergency, and if assemblies are dissolved, the assemblies may be restored also, is what Supreme Court said in S.R. Bommai's case. So this is the position. Now these are the, so when president should not invoke 356 for imposition of president rule or state emergency with the outweighing the constitutional provisions. That is the most important. If so, it is referred to judiciary for revival. So there are some situations were given which do not come within the meaning of this. When once president rule is imposed, center can take over executive powers and executive powers and legislative powers, but it should not touch the powers of the High Court. Should not touch the powers of the High Court. Here, then another thing is, if there is any internal disturbance in the state, it is the duty of the parliament to give proper protection. We are seeing on so many occasions, if any particular state, the law and order is totally failed, state police force is not sufficient, the center is sending their police force, CRPF, Central Police Force, they are sending to control the situation. So it is the duty of the parliament, union, to protect the interests of the states. And if there is a corruption, heavy corruption in the state government, reports are there, it should not be treated as a constitutional failure of constitutional machinery. Like that, some instances, there are certain circumstances which do not come within the meaning of failure of constitutional machinery. If any taking the advantage of any of such situations, a president rule is imposed, it is subject to judicial review, and the court may direct the union to withdraw this proclamation of emergency or president rule, as the case may be. So what are the consequences of president rule? When once the president rule is imposed, the state government do not have any power. Sometimes only president rule is imposed, the union cabinet is there, assemblies are there. Suppose union cabinet presents, but union cabinet do not have any executive power. Whatever bills were passed by state cabinet, they are subject to control by regulation by the center only. Secondly, the state legislature are there, they can pass laws, but the laws passed by state legislature are to be ratified by the union parliament. If after this proclamation of president rule, the president may, the Lok Sabha, the assemblies may be dissolved. When once the assemblies are dissolved, the president may direct the governor to dissolve the assembly. When once the assemblies are dissolved, it can be challenged. So the assembly can be dissolved after ratification by Lok Sabha and Rajya Sabha. First step, cabinet has taken decision, gave recommendation to President of India to impose president rule. As per the recommendation or advice of the cabinet headed by Prime Minister, the President of India under Article 356 proclaimed state emergency or president rule. So the proclamation of a state president rule imposed should be ratified by the 2/3 special majority of Lok Sabha and Rajya Sabha. Without the approval of Lok Sabha and Rajya Sabha, if state assemblies are dissolved, it is unconstitutional, is what Supreme Court said in S.R. Bommai's case. So here what happened was, these are the This is the consequences. Here, the when once president rule is imposed, all money bills and everything should be done as per the union will take over all executive powers and legislative power. The union will not touch the powers of the high courts of the respective states. If president rule is in one state, that state high court's power it should not encroach. Or similarly, suppose that state challenges in the first instance, the state government challenges the president's rule before High Court. Thereafter, appeal can be preferred to Supreme Court. That is the issue. So that is why the High Court's powers should not be touched. Legislative powers and executive powers can be taken over. Taken over. This is about these are the consequences. So how many times this proclamation of president rule can take place. President takes over executive powers and the president may do it or delegate it to any authority. The parliament takes over the legislative powers of the state government. The state government may take over or the parliament may allow the state legislature to pass laws and the union parliament can encroach subjects of state list and pass legislation for which state cannot question. If assemblies are dissolved, the parliament ultimately will make all laws. And the president of India will give direction in any respect of which he deems fit. So these are the consequences of rule. President rule. Now coming to the president rule when it can be withdrawn. Okay. So now president rule criticism also I told not only members of Constituent Assembly but also the team of Administrative Reforms Committee members also expressed that this 356 may be invoked violating the principles of misused. That is there for all these things I have given. Now the question is, in how many times this president rule was imposed in India? And first, in 1977, the Janata government came to power. Congress government headed by Mrs. Indira Gandhi at center was defeated and Janata government came to power. At that time, in 9 states, Congress government ruling 9 states and these 9 state governments were, in these 9 states, president rule was imposed. The Janata government, after coming to power, its home minister addressed to chief ministers of the states, your people have no more confidence, no more in your party. So it is decent on your part to quit the government and seek fresh people mandate. And this was unconstitutional and writ petitions were filed and ultimately since there are several writ petitions, all writ petitions were clubbed and referred to the Supreme Court entitled S.R. Bommai versus Union of India. So in 1977, Janata government dissolved 9 governments, imposed a president rule in 9 states: Rajasthan, Uttar Pradesh, Madhya Pradesh, Bihar, Punjab, Himachal Pradesh, Orissa, West Bengal and Haryana. In these 9 states, the Janata government imposed president rule on the ground that for defeat of for their miserable defeat in Lok Sabha elections at that time. So they challenged. Ultimately the cases were transferred to Supreme Court under one case entitled SR Bommai versus Union of India. Those points I will take. That is first time. And secondly, after this Janata government, which came to power, continued for 3 years only. It did not continue till 5 years, till completion of 5 years. Meanwhile, Mrs. Indira Gandhi started new party called Congress I, Indira Congress. Indira Congress. She traveled all over the country, and deep rooted in the souls of the people of India, and restored the love and affection from people all over the country, and came to power with absolute majority in 1980 elections. 77 Janata government came to power with untiring efforts of then leader Jay Prakash Narayan, who traveled all over the country to put down Mrs. Gandhi's government, and 1980 again Mrs. Gandhi came to power. See how the Janata government collapsed 9 governments of her party. Now Mrs. Gandhi also started collapsed 9 governments, 9 states governments, imposing president's rule, Those 9 states are 9 states in which government Janata Party was in government were Uttar Pradesh, Rajasthan, Madhya Pradesh, Bihar, Punjab, Orissa, Gujarat, Maharashtra, and Tamil Nadu. Again, some 2-3 states are different. So all these cases went to Supreme Court, clubbed and went to Supreme Court, and Supreme Court gave guidelines. So here, in earlier, Madhya Pradesh High Court said that the imposition of president rule unconstitutional, and then it referred to High Court, it referred to Supreme Court. Supreme Court said that the powers of the judiciary are limited unless there is any violation of constitutional provision or modified ill will, grudge, unfaithfulness. It was said, and later, so 9 states were collapsed in 1977, and this Mrs. Gandhi collapsed 9 states government in 1980 by imposing president rule. Subsequently, in 1983, Punjab, 1986, Jammu and Kashmir, 1988, Tamil Nadu, 1992, Nagaland and Uttar Pradesh, 1993, Madhya Pradesh, Himachal Pradesh and Rajasthan, Uttar Pradesh, 1995, 1996 and 1998, Bihar, 1998. These are the several occasions in which center imposed president's rule and put down the governments of the respective states. In view of several times president rules imposed, the aggrieved states governments approached the High Court, and the writ petitions filed in High Courts were clubbed and transferred to the Supreme Court. The Supreme Court under the head SR Bommai versus Union of India. So far as the decision of this is concerned, the Supreme Court, the 9-member constitutional bench of the Supreme Court unanimously decided. Here, on December 15, 1992, Madhya Pradesh, Himachal Pradesh and Rajasthan. On December 15, 1992, Madhya Pradesh, Himachal Pradesh and Rajasthan, 3 government in these 3 states, assembly president rule was imposed, and assemblies also were dissolved. When they approached, the state government said it is unconstitutional, but they went to Supreme Court. But on appeal to Supreme Court, the Supreme Court said the imposition of president rule and dissolution of assemblies in Madhya Pradesh, Himachal Pradesh and Rajasthan was constitutional. It is valid because the these three states, Madhya Pradesh, Himachal Pradesh, and Rajasthan, violated the principles of union government, outweighed the directions of the union government. Union government not only to take care of the state government but also give proper guidelines to state government if they do any irregularities. The union government specifically directed the state government not to involve in any religious activities, not to do not have any should not have any connection with the religious organizations, because religion secular, ours is secular state, and secularism is also one of the basic structure. Subsequently Supreme Court said, but contrary to the union direction, the chief ministers of these three states involved in cooperated, associated with religious organizations, some private social organizations. They are instrumental for sending some Karsavaks to Ayodhya. As a consequence of their activity, some Karsavaks went to Ayodhya, and it resulted in collapse of Babri Masjid on 6th December 1992. And this collapse of Babri Masjid resulted in very serious consequences, and the law and order in various parts of the country got disturbed. Particularly in Bhopal, law and order was badly affected, and so many states, particularly in these states, law and order was substantially affected, and that is the reason why the president rule was imposed in these states. So, imposition of president rule in these states, Madhya Pradesh, Himachal Pradesh, Rajasthan is constitutional, and it cannot be questioned, is what Supreme Court unanimously said. But the decision of the other states was kept pending. It reserved, the judgment in respect of the remaining state was kept reserved for the future date. But meanwhile, by the time the Supreme Court gave its final verdict so far as the remaining states collapse is concerned, meanwhile the term of respective assemblies was completed, and in those states, fresh elections were conducted, and fresh governments were formed, and others. So this is the position. These unanimously in this S.R. Bommai case, the Supreme Court 9 benches constitutional bench unanimously upheld the president rule and dissolution of assembly in respect of Rajasthan, Madhya Pradesh, and Himachal Pradesh, and Nagaland. It said it is unconstitutional. So in this particular case, this Supreme Court gave some most important guidelines. Number one, when once president rule is used to be imposed, the approval of the union cabinet headed by the Prime Minister of India is condition precedent. The president should not proclaim president rule merely on the recommendation of the Prime Minister. Prime Minister alone should not advise, but the union cabinet in its meeting headed by the Prime Minister must take decision and give it to the President for imposition of President rule. That is the first condition. When once the proclamation of President rule is in operation, it will continue for 2 months. Within the 2 months, it should be ratified by the 2/3 majority of the Lok Sabha and Rajya Sabha. If not approved, it must be withdrawn. Secondly, when once whether it is approval is there, if even though all conditions are there, because cabinet gives approval and president proclaims, and parliament, all belong to one team. President, Prime Minister, general normally, and because the Prime Minister, President of India is normally chosen by the Prime Minister with Prime Minister support. President of India is appointed. In the meanwhile, in the president times period, a new government comes. The ruling party is different. President who was in some other previous party might be different. It took place in Pranab Mukherjee's case, and now the subsequently the ruling party and president belong to one. When once any president or governor, they should not. They are absolutely immune from any political party. The speaker, the speakers, and governors and president, they must be absolutely immune from any political party. They should not belong to any political party. They should not show any favoritism. So that is why the Supreme Court said. So anyway, if president rule is imposed, it must be in strict adherence to the provisions of the Constitution. Secondly, the constitutional machinery, failure of constitutional machinery should not be as that of prescribed by the given by the Sarkaria Commission approved by the Supreme Court. So that is second thing. So this president rule should not be imposed malified. Malified means dishonestly, ill will, grudge, political rivalry should not be there. So if constitutional provision is violated, and if the president rule is imposed on malified grounds, then it can be challenged before the court, and the court is having review power to examine whether the president rule imposed in that particular state is correct or not. If it is not right, the Supreme Court, the court can order the union to revoke president rule and restore the assemblies if already dissolved. These are the various issues relating to president rule in SR Bombai's case. However, in president rule, this High Court powers of the High Court should not be, a union should not encroach the powers of the High Court, because in case the aggrieved approaches the court, the High Court should give appropriate direction. Now finally, last one is financial emergency. It is a very small one. And Article 360 financial emergency is it can be imposed by the President of India under Article 360 if the President of India is satisfied that the financial stability or credit of India in country as a whole or any part of the thereof. The President, on the advice of the cabinet headed by the President, Prime Minister, if the President of India receives report from Union Cabinet that the financial stability of the country is not good and the credit of India is not affected. If the financial stability of, if this President is satisfied that the financial stability of India is threatened or the credit of India is badly affected or threatened, he may issue proclamation of emergency under Article 360 of the Indian Constitution. When this Article 360 was designed, Dr. B.R. Ambedkar, Dr. Bhimrao Ramji Ambedkar ji, the father of Indian Constitution and the chairman of the drafting committee of our Indian Constitution, designed Article 360 and incorporated it in our Constitution, because our Indian currency and gold reserves must be in consonance with the foreign currencies. So there must be harmony between Indian currency, gold reserves with foreign currency, because our Indian currency and gold reserves must have sufficient value and purchasing capacity in international market. The Indian rupee value should not be put down. So in order to maintain harmonize between Indian currency and gold reserves with international currencies. This Article 360 was designed and incorporated in Indian Constitution by our father of Indian Constitution, our great B.R. Ambedkar ji. This thing. So this is the proclamation of financial emergency. When once a financial emergency is imposed, it will remain in operation. It will remove. It will remain in force for a period of 2 months. 2 months. First step: the Council of Ministers headed by Prime Minister should take decision and advise the President to proclaim financial emergency. When once it is imposed, it should be remain in force for 2 months. Within 2 months, this should be ratified by Lok Sabha and Rajya Sabha with a special majority, two-third majority of total members voting, present and voting. And in this financial emergency, like other, can be revoked, withdrawn by subsequent proclamation. After imposition of financial emergency, after 10-15 days or within 1 month also, it can before approval, before the matter is sent to Lok Sabha, Rajya Sabha also, it can be revoked. But however, same rule, if not approved, if any Lok Sabha members, one-third members can challenge it. If Lok Sabha is not sessions, after Lok Sabha elections, 30 days from the first sitting, this should be done. Or if it is not approved by not approvable, one-third, one-tenth of the Lok Sabha members can give representation to Lok Sabha Speaker if Lok Sabha is in session. If Lok Sabha is not sessions, it is given to President of India. And after that, after receipt of representation, within 14 days, the session should be completed for final decision. That is the procedure common for other things also. But so far as this, when once national emergency, financial emergency is imposed, when financial emergency is imposed, the center will take so many steps. So far as the income and expenditure is concerned, and it will have serious impact on revenue and expenditure, and all many bills, money bills are to be restricted, and the salaries of civil servants, state government and central government salaries may be reduced. In the salaries of high court judges and supreme court judges also may be reduced. All the reduced salaries may be reimbursed after normal time, after financial stability is restored. They may be whatever salaries of civil servants, state government, central government, and high court judges, supreme court judges reduced. The reduced salaries may be indemnified or restored after peacetime, after lifting of financial emergency. But even though the amount is not indemnified or restored or reimbursed, the affected parties, civil servants or judges, should not claim any claim on the ground of breach of duty. These are the consequences. However, these are the circumstances. If there is any financial instability is witnessed or credit of India is affected, then the President of India, invoking Article 360, imposes this proclamation of financial emergency. However, the India, since the Constitution came into force on 26 January 1950, we did not come across any situation of imposition of the financial emergency. In India, since 1952 till date 2023, financial emergency has not yet been imposed. However, there are some financial crisis took place in 1991. At the time, Chandrasekhar ji of National Front government was the Prime Minister, and necessary steps were taken. Even though there was a financial crisis, International Monetary Fund or World Bank did not come forward to rescue. Our Indian government managed with the cooperation of Bank of England, and Union Bank Switzerland, and other took other measures to normalize the situation and see that financial emergency should not be imposed. And adding fuel to fire, this COVID war brought about serious impact on financial emergency. We physically witnessed in 1992 the situation of petrol products during Kuwait war and other issues. There, with this situation, dear friends, this emergency provisions has been completed. This is my 214 lecture. 211 I delivered national emergency in Telugu language. 212 national emergency in English language. 213 state emergency and financial emergency in Telugu language. 214 state emergency or financial rule in English. Dear friends, it is inevitable for me to take lecture for not less than 1 hour, because every subject should be completed in 90 periods in classroom. In 90 periods in classroom, I know, understand, there are all videos are in few minutes only, because I know our students do not have any, cannot have patience to watch for hours together. But it is incompatible when once I take up lengthy project, giant project of almost all the subjects. But at the request of Telugu friends, I had to take up lectures in Telugu also. Otherwise, if you have patient hearing, I would be able to bring out many lectures. Kindly note that teaching lecture online is very difficult. Even if I get an opportunity, they will lecture in prestigious institution law school to deliver lecture. I need not take this much preparation, because the students would not raise any questions for my lectures except in few cases. But when once I deliver lecture in public, some intellectual giants may watch my lecture and I may subject to criticism. I have to take much care for more care for how my way of teaching in unaided colleges, university law departments is different. I should be more careful to teach national law schools, and I must take much more care to take lecture in this online lecture. Please, these lectures, delivering lecture is not easy. It is a struggle of lot of time. Unless I work for some lectures, there were instances I took nearly 1 week for delivering one lecture also. So please note of it. Uh, Please encourage. I told you the greatness of our legal education. In parliament privileges, I said in a many member of state as a state legislature or central legislature, within four walls of the house, state legislature or parliament, can speak anything, resulting in defamatory statement to great leaders of like prime minister or even union minister or even prime minister, chief ministers. They are not subjected to any defamation suits, civil criminal liability. But they should not, they may, the members of state houses or central houses may speak anything within four walls out of personal grudge or ill will, to speak wrong about union ministers, chief ministers, central ministers, prime ministers, but they should not speak anything wrong about high court judges or supreme court judges. That is the greatness conferred on by state judges of high courts and supreme courts by Indian constitution. It is a great privilege. What a great privilege and respect conferred on our members of judiciary. You keep in mind, so that they are conferred that much greatness, because their basis is legal education. You are in legal education, legal studies. It is your primary duty and responsibility to uplift the greatness of our legal education. Take care about classwork. Take care of, I know, even for five subjects in a semester, at least in every those institutions which are running successfully classes, they may insist the students sit 5 hours, but all are human beings, whether unaided private college student or aided private college student, university law department students, or prestigious law school student or national law school student. They are basically human being. How long they will be able to listen to the lecture is the primary thing. That is more important. We are witnessing in seminars conducted in your institutions, state seminars, national seminars. That is, the duration is around 5 hours. How many hours the participants are concentrating on these lectures? You are physically witnessing. I am constrained to, I am forced to deliver lecture for not less than 1 hour because I have to complete the whole chapter. If I teach this lecture of 1 hour in classroom teaching, I may take 5 6 lectures. Thank you very much for your patient hearing. Please inform your friends. I promise sincerely, honestly, daringly, dashingly. My lectures will give you wonderful knowledge. My lectures will give you wonderful knowledge. Whistling my lectures, taking the side heading, you can go through the exam successfully. After listening my lecture, you can wonderfully receive the lectures of any standard in national law schools or lectures delivered by the distinguished personalities of legal education. Thank you very much for your patient hearing, dear friends. Thanks a lot.